Welcome back. So the next chunk of Chapter 11 that we'll talk about is health, safety, and income security. All right. OSHA, Occupational Safety and Health Act, and it did a couple of things. The most important thing the Act did was create the administration with the same acronym. So it created the um, Occupational Safety and Health Administration, which is a federal administrative agency. So you may remember that from 2080, which effectively means they have the ability to write regulations and rules that have the force of federal statutes um, up to the point that they conflict with any federal statute. Right. So, and this is similar to other administrative agencies that have the same rulemaking authority, like the FDA or the FAA, which is the Federal Drug Administration, and the Federal Aviation Administration. And so OSHA has the ability to write regulations that effectively have the force of federal law. Right? And their objective is to ensure that workplaces are safe for employees. All right? 1970 legislation. Okay. So OSHA's main responsibilities include notification of employees of their rights. So if you've ever had a job, chances are there is that poster in the break room or by the time clock that is supplied by OSHA and federally required. So that's one of the things that OSHA does. Notification to employees of their rights. OSHA also has the ability to inspect workplaces, and this can be scheduled, but it can also be unannounced. You open up for business, and there is an OSHA inspector on site. All right, and I've actually linked a video of the process from the Department of Labor, the U.S. Department of Labor, detailing what an OSHA inspection looks like. Right? And if you've ever been at a place while an OSHA inspection was going on, you may have a feel for it. Okay, so the third thing that OSHA does is development of the regulations, which I've already referred to, but also enforcement. And OSHA has their own tribunal or their own court, right? So if you have a workplace and an OSHA inspector shows up and it results in a citation or a violation that causes a monetary fine to your company, and you disagree and you would like to appeal, that appeal takes place in an OSHA courtroom in front of an administrative law judge who really only hears OSHA cases. All right? That is your trial, so to speak, and of course the appeal goes into the federal court system. But that's what OSHA does. So I will encourage you to look at the video that I posted. Also, I posted some video footage from the West Texas fertilizer plant explosion several years back. As it turned out, that plant hadn't been inspected for a period of 5 years. OSHA inspections are not all that common because their budget has been cut, and cut in recent budget cycles. So they don't have the funds to inspect on a regular basis. In fact, a lot of what they do amounts to waiting for, or I shouldn't say waiting, but when something is, so someone has either died or an explosion takes place causing injury in a workplace, then OSHA shows up, and that's closer to their current means of operation. So I encourage you to look at those videos. And I know the video is a bit dated, but that was an interesting time because if you recall, when the West Texas fertilizer plant exploded, a couple of weeks later, the LP liquid propane plant in Florida exploded, and both were major catastrophes in facilities that hadn't been inspected for at least 5 years. So take a look at that. We'll press on for now. Workers' compensation. All right. Let's start in with the example to kind of mull that over. Jack and Jill suffer similar injuries when they slip on a wet concrete floor in Greg's retail store. Jack is an employee, Jill is a customer. Both Jack and Jill sue Greg. What happens with these lawsuits? Okay, we'll come back to that in a moment. So let's talk about what workers' compensation is. So these are state laws, so there is no federal workers' compensation law, but in every state, district, and territory, they're very similar. All right. And it is a framework. It functions like an insurance policy, and it has a framework for injuries, medical care. It also includes mortality tables, loss of limb, and other injuries like that. And there's a number, basically, that is for those types of injuries. All right, so let's revisit our hypothetical with Jack and Jill. All right, so Jack is an employee. He's going to be locked into the workers' compensation system. Jill was a customer, so she can sue, and this would be what we'd call a slip and fall claim. And she can sue civilly, right? So Jill could end up with $1 million. Jack could end up with, well, your health care gets covered. That's the compromise that is created by workers' compensation. If I'm injured at work, I don't have to worry about my medical care or my subsequent disability, or that there's a system in place for that. But in exchange, and that applies even if I'm at fault for my own injuries. So if I'm leaving work and I'm going down the stairs texting and distracted, and I slip and fall and I'm badly injured, well, guess what? Workers' compensation still applies, even though my injury was by and large my own fault. And the employers accept that because they know that you cannot sue for negligent workplace injuries. All right, so they'll take that trade-off. Okay. Income security. So Federal Insurance Contributions Act, which is FICA. All right. So this established our entitlement programs on both employer and employees. So if you've ever looked at your check and seen Social Security and Medicare come out either separately or together as FICA, know that your employer has paid that same amount. So the tax is actually twice the amount you see come out of your check. All right. Social Security is a system set up to provide for income in retirement. Medicare is a system set up for health care in retirement and other specified times. All right. ERISA governs private pensions, and it gets a lot more complex. As far as I'm concerned, that's what you need to know about it. It governs private pensions. COBRA, and usually I lead with the name of the legislation and then talk about the acronym, but this COBRA is actually a rider in 1985 on another piece of legislation, actually the Budgetary Act. So the name really is not meaningful to what it does for us. It allows you to stay in employee health coverage, group health plans, after your employment relationship ends. So this is put in place because health insurance on an individual basis is expensive. All right, because of risk. Right, if I have a group of individuals, they don't all have expensive health ailments, at least statistically. But if I have an individual person, it's difficult to know whether what that person has from a medical standpoint. And so insuring individuals is much more risky and much more expensive. All right. So for that reason, group health care is significantly cheaper than individual health care. And to kind of add insult to injury, when you leave a job, when your employment ends, then insurance gets substantially more expensive if you have to go on an individual basis. So to counteract that, COBRA allows you to stay in your group health plan with your employer after your employment has ended. All right, so that's what it does. Now, a couple of things to keep in mind. It does not require that your employer contribute to your group health plan. So if you were paying $200 out of each check, just for example, I'm pulling a number out of the air, and the actual cost is $350, well, after your employment ends, you pay the full $350 and possibly more, because the law allows for an administrative fee of, I believe, 2% to be tacked onto that. All right, but even still, that's a better deal than individual health care coverage. All right. Affordable Care Act, also called Obamacare. It just requires employers to offer health care coverage, but it also incentivizes them to do so by offsetting or requiring large deductions from taxable income for employers who do offer health insurance. Okay, employee privacy. General rule. At work, you do have a reasonable expectation of privacy in the workplace. In practice, no, you don't, because there's a gaping exception. To get rid of that general rule, all an employer has to do is tell you that you have no expectation of privacy in the workplace, and then you don't. So virtually every employee handbook says it has that language. You have no expectation to privacy in the workplace. So in application, you have no expectation of privacy in the workplace. All right. Polygraphs. Oh, and also before we move into polygraphs, you have zero expectation of privacy on company-owned computers, cellular devices, GPS devices, etc. Polygraphs. Not permissible for employment decisions. That's the rule for most employers. There is an exception for federal jobs that can impact national security and similar state-level jobs, and then a few other things that are articulated in the text. But the general rule, not permissible for employment, hiring, or promotion decisions. or even internal company investigations. All right. Drug testing. Legal if done in a systematic manner. So it can't be, you look baked today, let's go take a test. It really can't be that. It needs to be systematic. So you're drug tested when hired, you're drug tested when promoted, you're drug tested when you have an negligent accident on the workplace, right? That is perfectly legal. Or every year a certain random selection of our workforce is drug tested. That is also legal as well. But it can't be done on a you look baked today, or you don't look quite right, so let's go drug test you. That wouldn't be illegal. Okay, that wouldn't be legal, I should say. All right, so that's it for now.